The parliament is not supreme. It is the constitution which is supreme. Parliament cannot do what it likes to do. It can do what the constitution permits it to do. Independence of judiciary is an integral part of the basic structure of the constitution.
Judiciary should be elected in a multi-party democracy.
This would be leading to a chaos.
We need a new constitution.
A constitution should only have birthdays, no death days. We don't need a new constitution. Today, if you have to frame a new constitution, it's impossible for the parliament to come forward with a new.
It's Constitution Day today, and we have with us Dr. Balram Gupta. He's a highly distinguished, a highly venerated figure in the world of law and a guru to many a judicial luminary. A senior advocate, Dr. Gupta is a professor emeritus of law, and he was the director of the National Judicial Academy. He's also been the chairman of the Department of Laws at Punjab University, and until last year, he was director academics at the Chandigarh Judicial Academy. Dr. Gupta is a prolific author, writes very frequently, and his book, My Journey with Law and Justice, is a testament to his abiding love for law, judiciary, and constitution. So to commemorate this day, let's talk to him about his experiences with constitution. Sir, you have always said, you always very passionate about constitution. So tell us about this love affair. When did it start? How did it pan out?
You know, this love affair or my romance with the Indian Constitution started in the year 1964.
Okay.
I joined the law classes at the Punjab University. The Constitution was in its teens, only 14 years old. Mm-hmm. I was 20 at that time. I finished my law in 1966 and master's in 68. And therefore the Constitution also attained adulthood by that year, 18 years for that matter. And the romance ever since has continued for that matter. You know, this is a long journey. This romantic journey, we have grown together. In the sense, after I finished my master's, I was a parliamentary fellow at the Institute of Constitutional and Parliamentary Studies in the year 1968. Mm-hmm. And the kind of exposure that I got in that institute, we were attached with the Parliament of India, a member of Parliament, N.C. Chatterjee, who was a barrister. I was also associated with the parliamentary committee on delegated legislation. We could attend the sessions as such. And that particular exposure to the parliamentary institutions under the Indian Constitution was such a beginning for me. And I still relish those parliamentary debates, Nath Pai, for instance, Shakespeare in English that he would come out with. And therefore, it continued. 1969, I started teaching. I taught Constitution from 1969 to 1990.
That's a long
journey.
Yeah.
And you know, right from 1964, the cases which came up, they made a mark of their own in the growth and development of the Constitution. 1964 itself, the case relating to the Legislative Assembly of UP and the Allahabad High Court, UP High Court at that time. The contempt notice was issued by the Speaker, which was challenged before the High Court. The judge and the person who challenged that, they were issued the contempt notice by the Legislative Assembly, the Speaker. The matter was at that stage when the President of India referred for advisory opinion to the Supreme Court as to how to deal with this situation. Ultimately, it was held that the Legislative Assembly, the Speaker, are within the jurisdiction of the High Court, and they could entertain that.
Okay.
And therefore, this particular judgment, at that time the Prime Minister was Lal Bahadur Shastri. He sent that judgment, shared that judgment with the Chief Justice of US Supreme Court, with Lord Canning, House of Lords in England as such. And the Chief Justice received such good response. The then Chief Justice of India, P.B. Gajendra Gadkar, received such good responses. So it was such a beginning for that matter. And ever since then, when I was into teaching, the best of cases which made a mark have been a part of my journey. Early 91, I came into the profession. And therefore, I practiced Constitution.
So it's not just teaching, it's practicing as well.
Then I practiced Constitution. Early 2013, I went to the National Judicial Academy, the judicial education for that matter, from legal education to legal profession to judicial education. Now here I was emphasizing to the judges the relevance, the importance, the significance of the Constitution. It's a permanent companion of every judge. And I tell them that you must keep a copy of the Constitution in your office, the court, and the office residence, because minus that you cannot carry on. And therefore this romantic journey has been beautiful for that matter.
That's wonderful. So that's so inspiring. And so in a parliamentary constitutional democracy, who is supreme? Is it the parliament or the constitution?
Please. You know, when the Constitution was being framed, the English system was before the framers of the Indian Constitution. The very fact that you have a Constitution, therefore, the Parliament is not supreme.
Okay.
It is the Constitution which is supreme. Parliament, the Constitution is the creator of the Parliament. Okay. Parliament has to follow the discipline of the Constitution.
Okay.
Every member of the Parliament, the ministers, the Prime Minister, they take oath in the name of the Constitution to uphold the Constitution. It's unlike the UK system. There the Parliament is supreme, they have no Constitution.
Okay.
It is only in a constitutional parliamentary system. Parliament cannot do what it likes to do. It can do what the Constitution permits it to do. It has to translate the Constitution into action through their legislations. The supremacy is that of the Constitution. Only then this parliamentary democracy can really function effectively.
And so what led to the introduction of basic structure theory? Can you tell us about its journey?
Yes. You know, in my long journey, 60 years as such, with the Constitution, or the Constitution's 74 years journey for that matter, Keshwananda Bharati judgment is the judgment which is the savior of the Indian Constitution.
Okay.
Today we would not have had the Indian Constitution in shape as it is today, but for Keshwananda Bharati case. Right from the beginning of the Constitution, 1951, the first constitutional amendment introduced the 9th schedule in the Constitution. And that schedule was that the Parliament or the state legislatures if they enact any law which they feel is impinging upon the fundamental rights, which would otherwise be violative of the fundamental rights as such, by an amendment of the Constitution, they could insert it in the 9th schedule
Okay.
and give a protection from being challenged as violative of the Constitution. Now, this particular methodology of doing something which they could not do directly continued. It came to be challenged right in the beginning, 1951, in Shankari Prasad's case. The Supreme Court Constitution Bench allowed that. 1964's Sajjan Singh's case, again, the Supreme Court Constitution Bench allowed. Then 3 years later, Golaknath's case came up. In that particular case, they held, even by a constitutional amendment, they cannot violate any fundamental right.
Oh, so you can't
do
ignore them at all.
You can't do anything. Therefore, the entire thing was, the government was very keen that this judgment has to be overruled sooner the better. Constitution was amended. And by that time, 1972, Keshwananda case is of the year 1973. By 1972, 66 different legislations of the parliament and the state legislatures had been included in the 9th schedule, which means 66 legislations impinging upon the fundamental rights were protected through those amendments of the Constitution. All this came up before Keshwananda, Supreme Court, Keshwananda Bharati's case. Now, this one particular case came up before the Supreme Court, 13 judges bench. This has been the largest number of judges bench ever. Even thereafter, there has never been a larger bench than this bench as such. And they said, this case was argued for 72 days.
My God.
Spread over 5 months. Nani Palki was the main architect of this. Ultimately, by a majority of 7 to 6, thin majority, they held that the Constitution can be amended by the Parliament as long as they do not change or destroy the basic features of the Constitution, the fundamental elements of the Constitution. Those fundamentals have to be retained as such. Now, having laid down this, different judges wrote different judgments, but the balance was 7 to 6.
Okay.
The conclusions were recorded in the end. 6 different points were concluded. The second point was that the basic structure of the Constitution, Parliament cannot amend or destroy or change. And this summary was signed by 9 judges. 7, of course, majority, but it was signed by 9 judges. 4 judges did not sign.
Okay, 4 out of the 13.
That's right.
Yeah.
And therefore, in a way, this particular limitation on the Parliament, 9 judges held that. Because conclusion, they have signed to that, they have agreed to that aspect of it. Immediately thereafter, 2 years later, 1975, Prime Minister Indira Gandhi's election was challenged, which was set aside by the Allahabad High Court. Appeal came before the Supreme Court. Indira Gandhi challenged the judgment of the Allahabad High Court. Now, having done that, meanwhile, when that appeal was pending, the Parliament amended the law and said that no constitutional court can go into the issue about the election of the Prime Minister
Okay.
or that of the Speaker.
Okay.
It would be considered only and only by a body which would be provided for by a legislation of the Parliament, but not before the courts. It would not be challenged. Raj Narayan, who had challenged the election, also challenged this amendment, 39th Amendment of the Constitution. Both petitions were heard together. Now, this particular amendment was held to be violative of the basic structure.
Okay.
How the basic structure is violated? If you're excluding the judicial review of the top court or of the high court, the constitutional courts, that's the part integral of the basics of the Constitution. And therefore, you cannot do that.
Okay.
Consequently, the appeal was heard by the Supreme Court exercising judicial review over what already had been decided by the Allahabad High Court. And in exercise of the judicial review power, the Supreme Court held that the Allahabad High Court had wrongly set aside and her election was upheld.
Okay.
Now imagine if the 39th Amendment had been upheld by the Supreme Court, Supreme Court could not have gone into this issue
At all.
as such.
Absolutely.
Which means the basic structure protected even her election for that
Yeah.
matter.
Yeah. Absolutely. So it protected Parliament.
Absolutely.
Yeah. Absolutely.
In that context. In spite of this, they didn't want this limitation of basic structure. I remember that 7th of November 1975, the judgment came in Indira Gandhi's case. And 10th of November 1975, the bench was constituted, 13 judges, to reconsider Keshwananda Bharati
My God.
judgment. In spite of the fact, and Nani Palkiwala wrote a letter to Indira Gandhi saying everything, making it clear that you are saved because of basic structure as such.
Yeah. Yeah.
When the matter came up before 13 judges, there was no review petition. And even if there would have been a review petition, a bench of larger number of judges had to be called if they had to review that particular judgment. As such, they couldn't do this. The case was argued for 2 days. And the composition of the bench, Keshwananda bench, and this particular now had changed considerably.
Yeah. Yeah.
Chief Justice of India at that time was Justice A.N. Ray. He found that there is no way out as such. They can't succeed in their exercise, and therefore they did not meet on the third day. The matter ended there. And there is no record of this particular, there is no order of that as such. This is how the basic structure came to stay. Now, in a 50 years journey from 73 to 2023, we, in fact, in April, we celebrated the golden jubilee of basic structure of the Constitution.
Yeah. Yeah.
Basic structure of the Constitution. 22 times the matter had come before the Supreme Court, questioning different amendments as to whether they are violative of the basic structure or not. Out of 22 times, 15 times the Supreme Court has upheld the constitutional amendments, which means whatever they did had the stamp
Of
of
the
the
basic
Supreme
stru-
Court.
yeah.
It's only on 7 different occasions they found the amendments to be violative of the basic structure, which means it's not that the courts would not look into the entire matter and see for certainty as to whether it violates the basic structure or not. Only in such situations. Now, this basic structure, I mean, it has been used sparingly and with utmost caution and care, so that it actually doesn't impinge upon the power of the Parliament to amend the Constitution.
Absolutely.
But this 50 years journey would have been different if this particular basic structure, savior clause would not have been there qua the Constitution. You can imagine how the Constitution would have been
Yeah, absolutely.
changed every now and then
Yeah,
in that situation.
Yeah, would have been very whimsical.
Absolutely. You know, at the time when Keshavananda Bharati case was being argued, there were a number of nominees of the then Law Minister of India, H. Gokhale, Mohan Kumar Mangalam, who was the minister, cabinet minister at that time, and S.S. Ray, who was the chief minister in West Bengal. They were the think tank for the then prime minister. And they tried their very best. Even when the judgment was to be pronounced, the copies of the judgments were already there with the
My
government.
God, this is amazing.
I've written that in the
Yeah.
article which came in the Indian Express. But, you know, it has become an exportable constitutional item. Different constitutions have incorporated
Around the world.
around the world as such, or different versions of this imposing limitations on the exercise of power of the Parliament. And therefore, this is the North Star for the constitutional jurisprudence to be carried out in future.
That's
This in
excellent.
short is the story
Yeah.
of basic.
And so, why was Judicial Appointments Commission amendment violative of the basic structure?
That's right. You know, to deal with this issue, let me tell you, the commission which was proposed to be constituted, it included the Chief Justice of India, 2 senior-most judges, the Law Minister of India, and 2 nominees of the government, not from the field of law and justice. 6-member commission. Number 2, 2 members, if they take a particular view, they could overrule 4 members.
Okay.
I mean, the basic principle of majority
Was being
was
violated.
not, which means the law minister and one of the nominee, if they get together,
Yeah, yeah.
no appointment could be made as such in that situation. Now, there was no casting vote with the Chief Justice of India, assuming 3 members on one side, 3 members on the other side.
And he could, yeah.
He could not accept.
Intervene.
See, always a commission is constituted with odd number, because you have to decide the matter by majority for that matter. Such contradictions were there. Now, why these contradictions? They wanted to see that even if the 3 Chief Justice of India and 2 senior-most judges take a particular view on a particular candidate for elevation as a judge of the High Court or of the Supreme Court, 2 of the other members could
Can take a contrary view.
view as such. Now this means the independence of judiciary was impinged upon.
Absolutely. Because the party would have its own.
Absolutely, in that sense. Now, it was held in that particular case. Independence of judiciary is integral part of the basic structure of the Constitution. If you dilute that, then the very basic structure of the Constitution
Is, yeah, it goes for the
finished as
toss. Yeah,
such.
absolutely.
And therefore, this judgment is of the year 2016. 7 years have passed. These contradictions they could easily take care and come forward with a legislation, with an amendment, which could make this commission workable, feasible, possible as such. They haven't done
Hasn't
that.
happened.
They haven't done that. That would speak for itself
Yeah,
as to why they have done this.
Yeah, absolutely. And so, do you think the judiciary should be elected in a multi-party democracy?
See, this would be a leading to a chaos total as such. Now, judges, if they were to be elected, Supreme Court on the one hand, different high courts on the other. We have a party in majority in the center.
Yeah,
We
another
have
one.
different
Yeah.
parties. We are seeing what is happening at the parliamentary and the state legislative assemblies, what is happening as
And-
such. Particularly, judges can never be elected for the reason they are to see whether the parliament, the executive, is working within the constitutional
Constitution.
discipline or not. How can they exercise this jurisdiction unless they are not to be,
Absolutely.
that is the basic thing as such. I would say it is integral as part of the constitution, basic structure, that judges can never be elected in a constitutional parliamentary democracy. It's not workable. You know, what is the role of the judiciary? You have to see to that.
To safeguard the Constitution.
To uphold the Constitution.
Yeah.
And to ensure that each constitutional authority works in accordance with the Constitution. Be you ever so high, the Constitution is above you. And that they can do only and only if the
They are
judges are
Absolutely.
neutral.
Absolutely.
They need to be committed only to the Constitution and not to the political philosophy or ideology of a particular party as such. System cannot work at all in that
Absolutely.
situation.
Absolutely.
And I feel good that the system of collegium may not be perfect, yet this is the best
Working.
recipe that we could think
Absolutely,
of under the circumstances.
And so, why judicial activism? Why not parliamentary activism?
See, that's a very good question, and I have also pondered over this. Constitution has been amended already 106 times.
106 times.
6 times. That's on one hand. Parliament most of the time is consumed in what? Non-legislative activities. How much time is devoted to legislative activities? I think some researcher needs to work on that. You know, the kind of situation that we face every session that we, non-legislative matters. Now, take for instance, legislations which are required to curb arbitrary actions, abuse of power. Parliament doesn't come forward with those legislations. There is vacuum. Supreme Court is required to give directions where they find that there is no legislative act as
activity
such.
happening. Okay.
Now, parliamentary activism would be coming with more legislations, more of rule of law for that matter. Rule of law means more checks, controls, limitations on the functioning of the government. The government doesn't want it. Take, for instance, the institution of ombudsman. It has taken the parliament, 60 long years to come out with a legislation. And legislation came with a push of the judiciary, not otherwise.
Okay.
I worked on ombudsman for my doctoral work as such. The only reason being government was reluctant to have a check on itself. But in a democracy, this is most vital.
Absolutely.
This is essential as such. I had advocated constitutional recognition of ombudsman. And particularly, I even went to the extent of saying ombudsman in aid of judiciary. Many a time you hear whispers against judges. This has happened or that has happened for that matter. And there is no forum where those things
Can be addressed.
If we have a judicial ombudsman, the matter could be heard as such, in camera. He could submit the report to the Chief Justice of the High Court or of the Supreme Court. And if there is something found, some action is required. If not found, which means a clean chit to the judiciary, which again itself boosts
Elevates it. Yeah,
absolutely.
Absolutely.
And therefore, see, I would wish if the parliament could become more active in legislative process, but in accordance with the Constitution.
Yeah, yeah.
This would be a happy augury for that matter. Certainly they can do that. For instance, in 2022, economically weaker section of people, 10% reservation was provided through a legislative process. It has been upheld by the Supreme Court
Yeah.
as late as 2022, for that matter, which means basic structure is not a hindrance.
It is an
Only-
enabler. Yeah. Absolutely.
Only thing is that you must follow the discipline of the Constitution in that context. I'll be very happy because then judicial activism would be balanced.
By parliamentary activism.
That balancing is required.
And so, how do you strike a balance between fundamental rights, directive principles, and fundamental duties?
Yes. You know, we have the fundamental rights, we then have the directive principles, and then we have the fundamental duties. Originally in the Constitution, we had fundamental rights and directive principles. Internal emergency in 1975, 42nd Amendment of the Constitution in 1976, by which they introduced fundamental duties also. Directive principles and fundamental duties are not justiciable,
Sorry.
not enforceable
Okay. Okay.
through the courts for that matter. Why the directive principles were not enforceable? You know, the means, economic means for the government at that time when the Constitution came were meager. And therefore, it was thought, in fact, Article 37 stipulates that these directive principles shall be fundamental in the governance of the government,
Okay.
the system for that matter. Directive principles, only principles, directive as such, but fundamental in the governance of the country. Constitution itself stipulates that. And with the duties, they have used the expression fundamental duties.
Yeah. Yeah.
Now, fundamental is common to the three things as such. Harmoniously, they have to be correlated. In the sense, some of the directive principles have now become part of the fundamental rights.
Okay.
Right to education, primary education, has become a part of Article 21 as such. 21A has been added in that context. Now, this means, you have to harmonize things to be done in such a way that those principles gradually become integral part of the fundamental rights, for that matter. So far as duties are concerned, you can't claim fundamental rights if you're not ready to observe and follow duties as such.
Yeah. Yeah.
It is a basic jurisprudential concept. Rights and duties go hand in hand. They are together as such. Doesn't matter that they are not justiciable. They are not enforceable as such. I come to the court claiming a fundamental right. I have violated my fundamental duty. I have always advocated a fundamental duty must be read as a limitation on the exercise of your fundamental right. After all, they are fundamental. Two, there are limitations within the Constitution. And therefore, these three components need to be harmoniously interpreted. This recipe of three directive principles, fundamental rights, and it is a basic thing that rights are not absolute.
Absolutely, yeah.
Duties are limitations on your exercise of rights. And therefore, they must be.
Go hand in hand. And so, do you, there's a lot of debate about it, I hear about it. Do we need a new constitution?
See, in fact, I wrote on this aspect.
Absolutely.
The economic advisor, Deveroy from West Bengal, he wrote a piece in Mint of 15th of August 2023, saying that we need to embrace a new constitution. We the people need to embrace a new constitution. And he had two things to say. This constitution is colonial. Number two, the constitution today in 2023 is not the same what we adopted in 1950 as such. Now, I don't agree with both of these, and I have reasons for doing that. It was the 9th of December 1946, even before the independence, the Constituent Assembly met. They deliberated upon the entire thing, the Constitution, for 3 long years. In fact, to be exact, 2 years, 11 months, 18 days. And the best of constitutional minds contributed to that. B.N. Raw went over to US, to UK, and to other different countries. Directive principles from the Irish Constitution. Many of the things from the UK system, Australian system, Canadian system, we have borrowed for so many, thinking it should be the best possible amalgam of different constitutions for that matter. And therefore to say that this is colonial is absolutely wrong, is not at all. Yes, the Government of India Act of 1935 could be said to be the basic, but what vital changes have come into that through all these deliberations,
Amendments,
for that
yeah.
matter. B.R. Ambedkar's contribution in the framing of the Indian Constitution is immense, for that matter.
Absolutely, absolutely.
Absolutely. Now, 1950 till now, 74 years. Parliament has amended it 106
Six times, yeah.
And what rich contribution the Supreme Court has made in the growth of the Constitution. Obviously, the Constitution of 1950 cannot be
The same.
the same as
Absolutely.
that of 2023.
Sweet.
Yes, 74. We are going to complete 75 years, for that matter.
Yeah, yeah.
It has to grow with the passage of time. You know, I always compare a constitution as a plant. It grows with the passage of time. Sometimes it overgrows, pruning is required. Sometimes manuring is required.
It
Constitutional
needs- yeah,
manuring is
yeah.
required to really
Yeah, shore
nurture
up
this
its health.
plant as
Yeah,
such.
yeah, yeah.
And over these 74 years, yes, India is not what it was in 1950.
1947. Yeah.
The Constitution can't be. And then I was told that the normal life of a Constitution is 17 years as such. This is De Bruy's version. And he depended upon a Chicago study which they had conducted over there. You know, the long-living Constitution, the US Constitution, is of the year 1789. Think of it.
Yeah, yeah.
The Canadian Constitution, the Australian Constitution is long-living. French Constitution is long-living Constitution, for that matter. And I would say constitutions are meant to serve generation to generation, century to century, for that matter. And I have said in that article of mine, a constitution should only have birthdays, no death days. No death days as such. We don't need a new constitution. Another reason for not to have a constitution, new constitution. You know, constitution was framed from 1946 to 49. Today, if you have to frame a new constitution, it's impossible for the parliament to come forward with a new. Even legislations are difficult to be carried through.
Yeah, yeah. Yes.
To have a constitution. And therefore, Indian constitution was crafted so very well. It must live long, would serve, continue to serve. And that is the reason why basic structure was required. If there would have been no basic structure, we would have been requiring every now and then a new constitution as such, for that matter. And therefore, I would urge, let this constitution grow with the passage of time. It would meet all situations. You know, judicial review, parliamentary process keeps the constitution as a living organism.
Yeah, absolutely, absolutely.
And I would urge every authority, whether parliament or the executive or the judiciary, they are under the constitution. And constitution must be followed. You know, the greatest pillar of rule of law is the constitution. And the greatest pillar of the constitution is the basic structure. We don't need anything else in that context.
Absolutely. This is amazing, sir. Thank you so much for your time. On that note, we will conclude it. So, Indian Constitution is a living being and it's in good health.
Absolutely.
So,
It's in good health and it doesn't need any surgical process to be carried out. Thank you
a
so
very
much.
happy birthday to it.
Thank you so much.
Not at all,
Such
sir.
a pleasure.
A pleasure. Thank you
Pleasure.
so much.